SJC-11507, Commonwealth versus Pina.
Mr. Fogarty, good morning.
Morning, Your Honors. May I proceed?
You may.
All right, my name is Edward Fogarty of Springfield, and I represent the appellant in this matter, Mr. Emmanuel Pina. Several issues arose during the trial. One of those issues involved jury instructions. The trial counsel requested several times instructions with regard to self-defense. And that morphed over time during the course of the request for those instructions to a request. He termed it as accident. I had phrased it as accident. I believe the Commonwealth has corrected it to be a question of whether it was transferred self-defense intent.
But did that accident, or whatever you want to call it, request come after the closing?
It did. My memory was his first request for jury instructions asked for self-defense. His second request for jury instructions with regard to manslaughter. And it was only in the post-charge conference that he made clear that he was asking for self-defense transferred intent. I believe in the fourth request for instructions, he also made a request for self-defense. It wasn't as clear, however, I don't believe, as it was in the post-charge conference.
What is transferred self-defense?
In this case, Judge, it would be that, as you know from the facts of the case, they had gone down Hancock Street, both the victim, Mr. Eason, and the defendant, Mr. Pina. Pina turned right onto Jerome Street, where he entered into a gunfight with Santos.
Right, and there was a self-defense instruction in that, right?
That's correct. That's correct. And it's the theory of the defense that in the course of the gunfight on Jerome Street, directly across was Bird Street, on which Mr. Eason is found lying either dead or dying. And that during the course of the self-defense on Jerome Street, where he's having a shootout with Mr. Santos, that some of the shots that were fired there were fired in the direction, it's pretty clear from the evidence, were fired in the direction of Bird Street, and that those shots could have resulted in the injuries to Mr.
I could be wrong, but I thought the chronology was the shooting in front of the restaurant that results in the killing of Mr. Montero, the cook. Then he chases after Eason.
Right.
Eason's gunned down, and then there's the shootout with Santos.
Well, that's a question of fact. Certainly the Commonwealth would say, I'll agree with you about Mr. Montero. That took place
Right, so
at the bar.
Obviously.
Then gunshots are fired and all parties flee the area. While running down the street, the Commonwealth is going to say that the video, which there's extensive footage, which has been provided, I believe, to the court, the video shows Mr. Eason grabbing his back in the area where the fatal shot, I believe, was found. But it's not conclusive. It also is part of the evidence that Eason then had to turn left onto Bird Street. I don't know that there's any testimony that somebody sees him do that, but he obviously goes down Bird Street where he falls or collapses and dies. At the same time, Mr. Pina has gone up Jerome Street where he enters into a gunfight with Santos, firing in the direction of Bird Street. So it could equally be that the gunshots that ultimately result in the death of Mr. Eason could have been fired from the area of Jerome Street in the direction where Eason is. That's where he is. He's on Bird Street.
So what you're saying, I now think I understand your brief a little better. Are you saying that it's during the Santos-Pina gunfight that in the light most favorable to the defendant, that's how the cook in the restaurant and Eason get shot?
No, okay. That's how Eason gets shot. The cook clearly is shot back on Hancock Street at the K. Carlos bar. That occurs when all parties are emptied out of the bar. And while on Hancock Street, there's an Adelino Gonsalves who's about to get into a fist fight with Eason. At some point, the co-defendant in the case brings a gun to the fight. There's a witness, Mr. Adalberto Beto is his nickname, who says, I see Mr. Pina there, I know Mr. Pina, and he then either takes the gun from the co-defendant or the gun is transferred to Mr. Pina. Pina then fires the gun in front of the restaurant. That discharge of the firearm at that time enters the restaurant and unfortunately strikes Mr. Montero, the cook, who collapses and dies. At that moment, everybody runs.
Okay, but as to, let's focus on the death of Mr. Montero, which is one count of the, are you saying that that he was acting in self-defense and simply missed with regard to that shot?
The trial counsel raised the request for both voluntary and involuntary manslaughter as to the death of Mr. Montero. His theory at the trial was, and I believe it is consistent with the evidence in the light most favorable to the defendant, that at the time that they entered into the dispute or the fight is occurring on Hancock Street in front of the restaurant, Mr. Adalberto Brandeo, otherwise known as Beto, comes forward and points in the direction of Mr. Pina while he says Pina has a gun. The defendant counsel argues that when he's pointing the finger, it could have been a gun. There's another witness from inside the bar, whose name escapes me, who bears up under examination that, yes, it could have been a gun. Weak theory, to be sure. But nevertheless, there's evidence presented to the jury that it could have been a gun in Mr. Brandeo's hand at that time. The theory of the defense is that Mr. Pina, if he did shoot it, fire the gun, fired it either in defense of himself or of his friend, the co-defendant, or he fired off a warning shot in a reckless manner, wanton and reckless, that resulted in the death of Mr. Montero, the cook, who's standing in a window overlooking the street.
Okay, well, let's divvy them up into two, into the so-called, are you claiming that there should have been a transferred self-defense instruction with regard to the killing of Montero?
No,
Okay, so with that, it is purely involuntary manslaughter.
correct.
And what does the evidence say as to where Eason was with respect to where Pina was with respect to where Montero was?
Right. The evidence would show that at the time that Pina fires the shot, Mr. Eason is in front of the bar and approximately in front of the area where Mr. Montero would have been standing inside a window. I believe at that time, Mr. Eason is attempting to get to his car, which is also in front of the restaurant, and that's when the shot is fired.
But how do you get involuntary manslaughter if any of the intent would be suffice for malice? Because there's an intent to kill, intent to do all the other prongs with regard to Mr. Eason and this transferred intent for Mr. Montero. Yeah,
the theory would be that it was done recklessly and with wanton behavior as a warning shot, and that was what the defense counsel argued, that when Mr. Adalberto Brandeo came forward and pointed in the direction of Mr. Pina, his finger is pointing in that direction. If the jury accepted the argument that in fact he had a gun, then it would have been that Mr. Pina fires off either a warning shot or fires in self-defense against Mr. Brandeo, and not specifically with the intent to kill Mr. Eason.
And with respect to the death of Mr. Eason, I gathered there was a self-defense instruction?
There was. And indeed, there were charges brought with regard to the shooting of Mr. Eason, and the jury found Mr. Pina not guilty of the shooting involving Mr. Santos, I'm sorry.
right, yeah, you meant Santos all along, not
excuse-
Eason, yeah.
Yeah, I'm
Excuse me.
referring to the death of Eason. That's why,
I'm sorry, my apologies.
with regard to the death of Eason, did he receive a self-defense instruction?
No.
Okay, and what is the evidence, since Eason was running, that he was acting in self-defense when he shot him, I believe, in the back.
You would have to assume that the shot that resulted in his injury to the back occurred while he was on Bird Street and not necessarily while he's running down Hancock Street. Certainly, the Commonwealth is going to argue that the video shows Mr. Eason grab his back, and that's where the injury occurred while he's on Hancock Street before he gets to that intersection where he turns left on Bird Street. The defense theory in the case was that, in fact, we don't know why he's grabbing his back. All we know is that he grabbed his back, he ran left on Bird Street, and it's on Bird Street, some distance down, where he collapses and dies, at the same time that the gunfight is occurring between Santos and Pina up on Jerome Street.
Shot like 3 times in the back?
I think it was twice, but it could be three.
Twice in the back.
Does that, by the way, as far as the sight lines and everything, is that geography even possible, that there's a gunfight with, between the defendant and Santos, and that 2 bullets could end up where Eason is, in his back?
Well, there's a couple of issues there. The Commonwealth in its brief argues that if you look at the diagram, there's an angle. So that Jerome Street comes down straight, Bird initially, I believe, is straight, and then it angles off a bit, and so therefore it would be virtually impossible. However, there's nothing in the record to point to that other than this diagram, and there's no testimony with regard to how accurate the diagram is, how the measurements were made, whether the angle is such an angle, and so forth. Furthermore,
Well, the witnesses all say that's the street and it's an accurate depiction.
Pardon me?
I mean, they don't have a surveyor, but the witnesses, and they all say, all the police officers say, that's the street,
Well,
that's an accurate depiction, that's where the guy was, that's where the other guy was.
I understand, but that theory is contradicted by the location of a spent .45 caliber projectile or bullet beyond where Mr. Eason is found dead. So at considerable distance beyond that, police locate a spent .45 caliber bullet located in front of a funeral home, I believe it is, and it's pretty clear that's the only way it could have gotten there was having been fired by Mr. Pina during his self-defense up on Jerome Street.
If we can turn to the issue of the peremptories.
Yes, Your Honor. During the course of the...
Great. I mean, I know the facts. I'm just trying to look to the issue of prejudice. What is, are you saying that it is structural error and that the effective denial of that one peremptory is sufficient by itself, or that there must be, your sister, I guess, in a moment will say no, he must have preserved it as saying that I would have used that peremptory on one of the sitting jurors had I had it, and therefore I am prejudiced, Your Honor, by your miscounting the number of peremptories?
Well, I believe counsel, in effect, did preserve the objection. He clearly didn't say, I object. However, he did raise he was the one that the court says you don't have any more. He says, I think I do. And then shortly after that, he readdresses the court and said, I have 2 more peremptories. And the court says, no, you don't. I'm keeping accurate records. And the clerk then chimes in to say, yep, we've got accurate records here. You don't have any more. I would argue that in effect is preserving.
Okay, so let's
his
assume
objection.
let's assume you're right as to that. Is there not also an obligation for there to be a proffer that, Your Honor, we just put juror number whatever on the jury, and I would have used that peremptory to strike that juror?
Well, certainly there's case law to that effect. I can't argue that. However, I would point out that both the jurors that were seated, number 69 and 80, ultimately wound up being jurors on the panel that decided the verdict. Juror number 69, her husband had been convicted of operating under the influence, and he was found to be attending Alcoholics Anonymous treatment or care. Clearly, it could well have been, in a case such as this, that the defendant and or defense counsel would have said, well, we don't want to have such a person on a panel where we're contemplating an intoxication defense, because at that point in time, he had raised the issue of an intoxication as to raising it as an issue in the trial. And clearly, it would have been in his interest, in the defendant's interest, not to have somebody who could be somewhat prejudiced about people who are under intoxication.
He didn't raise it, he ultimately didn't raise it, right? There was no
He did not.
Right.
No. And that's a further claim in the case. I would address it if you would. We made an argument that there was ineffective assistance of counsel insofar as he failed to raise an intoxication defense to specific intent in this case. He had presented that he was going to present to the court Mr. Pina's sister with regard to his having been voluntary intoxication. The court addressed the issue a number of times during the trial. Ultimately, he chose not to present the sister. He claimed it was because the sister was unreliable, and he didn't know how she would withstand cross-examination. I believe that was in his affidavit. Our argument is that there's virtually no rational reason for not putting forward that witness and the others that would have been available that we located. As the court has just addressed in its comments with regard to the jury instructions as to self-defense and manslaughter, the theories in these case may have been somewhat weak. Furthermore, use of an intoxication defense would not have been inconsistent with the other defenses that he was attempting to use in the case pursuant to his request for the jury instructions. And our argument is there's just no rational basis for not putting that evidence forward.
Anything else that you have?
I have nothing else to
All right.
rest on my brief.
Thank you. And we'll hear from Ms. Lewis.
Good morning, Your Honors. May I please the court, Sarah Lewis on behalf of the Commonwealth. With me today is the trial prosecutor in this case, District Attorney John Pappas. I would also like to recognize members of the victim's family, Giovanni Eason's family, who are with us in the courtroom today. We are asking this court to affirm the defendant's conviction for the first-degree murder of both Giovanni Eason and Manuel Montero. I think to begin with the instructions that were requested at trial, the involuntary manslaughter and the accident, I think it's important to look at these events that happened here as a continuum rather than in isolation. The defendant entered this bar, got into a fight with the victim and others inside the bathroom, people who were fighting inside the bathroom, then went onto the street where the fight continued. The defendant at that point took a gun from the co-defendant Tavares. He interjected it into the mix. He pointed it directly at Eason and chased after him, pursuing him down Hancock Street, at which point Eason turned onto Bird Street. The defendant turned up Jerome Street and engaged in this gun battle with Timothy Santos. Again, this all has to be looked at a continuum and not in isolation.
The shooting of Mr. Eason happens on Jerome, correct?
I'm sorry, say it again?
The shooting of Mr. Eason happens where? On what street?
It happens on Hancock Street. So what happens is that there are, in fact, the victim, Giovanni Eason, suffered from 3 gunshot wounds, 2 to the torso, which were the fatal wounds, and 1 to, I believe, the shoulder.
And then Mr. Eason, still obviously alive, turns himself on Bird Street.
Right, and I would point out that with respect to the accident instruction aspect of this, there's no evidence of when he turned on to that street, insofar as he could have already been down and had that fatal wound and fallen by the time the gun battle ensues on the top of Jerome Street. But to your question, there is evidence, and the video speaks for itself on this point, that as the defendant is pursuing Eason down Hancock Street, again, before even turning on to Jerome and Bird, respectively, the victim, Eason, reaches for his back. At first, his arms are to his side. He then reaches to his back, the very place, the lower back, where one of the fatal gunshot wounds, I would say the most serious one, the one that lodges in his body, occurs. So what would have happened here for this accident of transferred intent to even be possible is that 2 gunshot wounds, 2 fatal gunshot wounds, would have had to been lodged from the top of Jerome Street. And
Where are the shell casings?
there are 3 shell casings on Hancock Street. One that's right in front of Carlos, which is, I think, a reasonable inference would be the one that hits Montero. There is another shell casing on Hancock, and as they're running down the street, and then I misspoke. There are 2 shell casings, and the third one I believe was not located, which is reasonable given the amount of people and running that is happening here. But I think it's also fair to infer that the defendant in this case could have fired that third shot right before he turned on Jerome Street, down Bird, which is why there would be a spent bullet in front of the funeral home. I think that it is important for this court to look at the map, which is at page 110 of the defendant's record appendix, and to look at the angle of the streets. The defendant presented absolutely no evidence that the angle of the streets would have allowed for this projectile to even angle down to get to Easton's body, to the extent he hadn't fallen yet and hadn't died at that point. But again, I think the most important evidence is that video where he does reach for his lower back, and as the medical examiner testified, that is the most serious of the fatal wounds. And I think the other just really important point here to make is that the predicate for the defendant's argument for an accident instruction is that he was entitled to a self-defense instruction in the first place with respect to that gun battle on Jerome Street with Timothy Santos. He received a self-defense instruction, but I would suggest that he received more than he was entitled to. He was the one, again, and that's why I encourage the court to look at the events here as a continuum. He is the one who takes the gun, interjects it into the mix, and pursues Eason from the very beginning outside Carlos, the restaurant, down Hancock Street.
I'm sorry. Is there any way to tell where Mr. Santos was standing? Is that in line with where Mr. Eason was ultimately hit, or was he standing somewhere else? I know there's damage to some vehicles.
Right.
And there's clusters of shells, 380 shells and 45s from the 2 different guns. But where was Santos standing when he was hit?
The evidence shows, and the video does show this as well, is that Santos comes up Jerome Street, I believe after Pina had run up Jerome Street, and that Pina was towards the top of Jerome and Cushing, and that Santos was down further on the hill. The 45 caliber shell casings are found further up on the hill, and the 38 caliber are further down. So that's the evidence with respect to that. So perhaps they were shooting at each other in that way, which is what the defendant is arguing supports his theory that the 45 calibers could have come down the hill. But again, for that to work, first of all, two fatal gunshot wounds would have had to hit Eason on Bird Street, and the evidence shows that at least one entered his back on Hancock Street, and second, the angles of the street would have had to allow for that to happen, and there was certainly no evidence, and I say what the evidence would be the contrary given the map.
In your position, it doesn't really matter because the video evidence of him being shot in the back, the medical examiner said that was in and of itself a fatal shot.
The medical examiner's testimony was that he died from 2 gunshot wounds to the torso. The 2 gunshot wounds to the torso, one of which was the shot on Hancock Street, was to the lower back, and I would say the video shows that was the shot to the lower back, and that was the shot that was the more fatal. It entered the critical cavity of the body to have resulted in his death.
If you could turn to the peremptories.
Yes. I would say, Your Honors, in the first place here, this was a miscalculation by the judge that didn't arise to error. And it didn't arise to error because no deprivation occurred here. What happened is that
Well, sorry, it's error, but you're claiming it's not prejudicial error, isn't it?
Well, I think that's our second argument. I would just point out that factually what happened was that the defense attorney exercised a peremptory on a particular juror. That juror was excused. At that point, the judge says, "You're out of peremptories." That was wrong. He had one more left. But the error has to arise from a deprivation where the defense attorney would have then tried to exercise that peremptory on another seated juror, and he never did that. To the extent the court does find error from the miscalculation, there is no prejudice. I would say there's absolutely no objection by the defense counsel. He, in fact, miscounted as well, and what happened was that after 2 more jurors were excused for cause, the defendant said, quote, and this is at the 3rd volume of the transcript, page 60 to 62, he says, "It was my understanding, and I might be wrong, that I had 2 challenges left, and that was Mr. Pappas' and Mr. Moss's also. Maybe I'm wrong." And when the court said, "You are, I've been keeping close tally on all the challenges," the defendant said, "Okay." A part of the purpose of requiring an objection is to alert the judge to the miscounting, and in this case, to give her a chance to correct it. And that she was never given the chance to do that here because the defendant didn't press it any further. He also didn't ask for additional peremptories, as the judge has discretion to give more. He did not attempt to preserve his rights by challenging either of the last 2 jurors for cause, nor did he attempt to use a peremptory on one of the seated jurors.
You're dealing with, there was a co-defendant, so, right?
Yes.
So you're dealing with 64 peremptories. And yes, the judge's count was off, but if you're dealing with 64 peremptories, it seems that there should be an objection if the count's off, not just you might be off.
And I agree with that, and there wasn't in this case, if that's what you're getting at, Your Honor. And I would say the defendant, as I mentioned, miscounted 2. He said, "I think I have 2." It was really 1 by the Commonwealth's review of the record. So there was some uncertainty here, and again, he has not shown, nor did he show below, that he would have exercised his last peremptory had it been available to him. I also will note that the last 2 jurors who were sat said that there was nothing that would, they would be fair and impartial in the case, and the judge had the ability to credit that, which she did. So there, again, there's no showing that this jury at all was fair and impartial. I will also note that the defense counsel said he was content once the jury was sat.
You could turn to the video identification by Detective Weiss.
Yes, I will turn to that issue. I would say it was entirely proper here for Sergeant Detective Wise to identify the defendant as the person walking into Carlos. He never identified the defendant as the shooter. Instead, it was merely identifying him as the person walking into the bar. I think it's critical here that this was entirely cumulative. 2 other witnesses had already identified the defendant as walking into the bar within seconds of the same time frame that Wise did. And also, it was not contested that the defendant was inside the bar that night. It was not contested by the defense counsel during cross-examination of any of the witnesses, nor during his closing argument. So I also think, just generally speaking here, this testimony by Sergeant Detective Wise was a narrative. It synthesized this video for the jury, and that was entirely proper in this case, where different portions of this video had been shown to multiple witnesses at multiple angles and segments, and it was important to present this, to package this for the jury and present it to them for a clear understanding of the case.
Usually, I don't think always, but usually when you have a witness, and here a police officer on the witness stand, looking at what the jury's going to look at anyway, and saying, "Oh, that's John Smith," there's usually a relationship, or they know each other, so that there's more ability of the police officer/witness to say who that is.
And I do understand that, and that's something that's discussed in Pleas and its progeny. I think the other problem that's raised in those types of cases is also when an officer only knows the person based on their role as a police officer. Here his testimony only came from the fact that he was lead investigator in this case. He had reviewed witness state, and I think that makes it...
It would be problematic, but you had 2 other witnesses who said, "That's Emma," or "That's
Right.
Mr. Pina."
Right, but I do think this is respectfully distinguishable from the Pleas line of cases, in that his familiarity with the defendant was derived from his role as lead investigator, and I don't think that's problematic.
We don't have a lead investigator exception, though, that says if you're the lead investigator and you have all this knowledge, you can identify people on videos who are otherwise unidentified, right?
Right, but here, I understand that, but here, the defendant was otherwise identified, as you point out. But I will say he did testify that he reviewed the video on multiple occasions. He reviewed witness statements and interviews.
But I'll press you a little bit. If you had a bank robbery, not this case, you have a bank robbery, it's an ID case, and you have a police officer who's a lead investigator who does a heck of a job, does a very thorough investigation, knows as much about that case as anybody on God's green earth, that police officer can't go into court and say, that's John Smith.
No, and I don't think he can say if it's the video of the robbery, and I think we have a distinction here, where it's just this identification is not of the defendant as the shooter. He specifically doesn't do that. All he says is he's walking.
It's the guy in the white shirt, and then minutes later, the guy in the white shirt's the one doing the shooting, right?
Right, but I will point out just one other important factual point here is that there are multiple men in white shirts in this video, and which is, I think, also shows the probative value of it, and just in terms of specifically where the defendant's defense is misidentification and third-party culprit. He's distinguishing who's on this video, but you know, to the extent this court finds it error and the Commonwealth does not concede that, then I do think it's not prejudicial at all, and I would point the court's attention to a recent opinion in Vatcher, which is 469 Mass 425, a relatively recent opinion where the court found that the testimony was improper but not prejudicial, not reversible error.
We're going to talk about whether or not the ID on the video was proper or not. I think that Justice Gaziano's point may be that, well, if you have a police officer on the witness stand who doesn't know the defendant any better than the jurors do and has looked at the tape many times, the jurors can do that, but he's the lead investigator, he's the police officer, and somehow get anointed with some special ability because you're able to look at the video and you're able to say, oh, that is the defendant, that there's some concern about that, because why can that police officer, just because he's the lead investigator or has looked at the video a lot, do that any better than the jurors? If there's a situation where the witness on the witness stand can do it better than the jurors because it's next to a neighbor or whatever reason, that's different. But here, I'm not sure there's anything to say that this police officer could do that any better than the jurors.
And I understand Your Honor's concern. I would say that in this particular case, I think he could do it better because of, again, the fact that this video, and there was ample video in this case that had been shown to different witnesses at different angles, and he was synthesizing it. And I think that was particularly important and probative here. Again, to the extent the court has a concern about that, I would narrow this case to its facts and with respect to the amount of video that was shown, once again, the number of people in white shirts, the misidentification defense. But to the extent there is error, again, it was entirely cumulative. This wasn't a contested issue. It was an isolated identification of the defendant only walking into the bar. What the cases have also said is that where the jury does have the video and are able then they are capable of verifying the witness's testimony, here Wise's testimony, and independently reaching its own interpretation. And that goes to the prejudicial nature of it and makes it not prejudicial or reversible error in this case. If the court has no further questions, the Commonwealth just asks that
Okay, we'll be remiss, perhaps not remiss, but I will take note that although it will have absolutely no bearing on the outcome of this decision, I congratulate Mr. Pappas on becoming the DA. So I congratulate you, and again assure you it will neither help you nor hurt you with regard to our decision in this case, but I do note the honor that you were given and the responsibilities, and we thank you for accepting them. All right, we will
Thank you, Your
adjourn.
Honor.